Welcome back to Nairobi Legal Insights. In today's episode on contract law, we're going to be focusing on boilerplate clauses. These are standard clauses in contracts that you must actually pay close attention to. In any sort of a contract you've encountered, we have standard clauses in that particular contract. And as far as this particular video is concerned, I want you to be in a position to understand and look out for these clauses so that you know how you can shield yourself from potential legal liability. And when we talk about boilerplate clauses, these are clauses that you're going to encounter towards the end of an agreement. So if it's a loan agreement that you've entered into with a bank, you will oftentimes find these clauses towards the end of the agreement. And one key thing you need to take note of is that these clauses are rarely negotiated. Basically, they're just within the contract and there's no room for negotiating them. And of course, the other key takeaway point is that in most cases, we may assume that these clauses are the same across all the contracts, but this is never the case. And so you need to pay close attention every single time you receive a contract and look out for these boilerplate clauses that we are going to look into today, because they clarify the relationship between the parties. Now, the first boilerplate clause is what we call the entire agreement clause. When you receive an employment contract or a contract for purchase of a car or a loan agreement, there will be a clause that is called the entire agreement clause. And the essence of this clause is that it ensures that whatever was discussed in the past is excluded in this current contract that you're entering into. So the essence of calling it an entire agreement clause is to ensure that you don't actually go ahead to bring in pre-contractual negotiations that you might have agreed upon in the past. So basically, by focusing on the agreement that you're signing, that is what is binding you as the parties to that particular contract. And as you can already see on your screens, all the claims of misrepresentations are taken out by this specific clause, because a person who signs a contract that has an entire agreement clause is bound by the four corners of that particular document. And by the four corners of the particular document, what I mean is that you're only bound by what is written within that contract, and this is the essence of an entire agreement clause, excluding your past negotiations, anything that you might have agreed upon. And remember, as far as this clause is concerned, it will say that the bargain of the parties cannot be supplemented or valid, or rather varied by any other previous agreement or document. So focusing on what you're signing as the ultimate document that is supreme to any previous negotiations that you've had. This is the entire agreement clause. The second boilerplate agreement is what we call the no reliance or no representation clause. So the essence of this clause is that all the pre-contractual things that you might have talked about with a party to a contract prior to signing the contract will be excluded. So what I mean here is that once we say there is no reliance in a contract, it means that you cannot then go rely on the previous negotiations. And this clause is going to eliminate all those previous negotiations. But in the event that you want the previous negotiations included in the contract that you're signing, then consider adding those terms and conditions that you actually feel are favorable to you. Otherwise, as long as this no representation clause exists within a contract, it is going to exclude any reliance on the previous negotiations you had, meaning that you're only going to be bound by that which is within the contract that you're signing. The third boilerplate clause is what we call a no waiver clause. So if party A and B enter into a contract and party B is not fulfilling certain things within the contract that were agreed upon, party A is ignoring that as it occurs, it doesn't mean that party A has given away his or her right for certain things to actually be done as it was agreed before. So to put this into context, if suppose James is renting an apartment and he's not paid rent for a month, he goes ahead and explains to the landlady that, hey, look, I have a problem with my cash flow. I will be able to pay in the next 2-3 weeks. And the landlord goes ahead to allow this to happen and tells James, but next time do not repeat this. Now 6 months down the road, the same occurrence happens again. The question here is, the fact that the landlord forgave James during the previous 2 occasions does not actually mean that James is to be forgiven for more times to come. And so you may wonder, will James have a cause of action to claim that, hey, the landlord is actually terminating my lease agreement simply because I don't pay rent on time, and he forgave me the past 2 times, and this time around he has refused to forgive me for the late payment. So when we talk about a no waiver clause, what we mean here is that the landlord has that discretion to actually waive a default of the rent because maybe they understand your story. They may do it once. Next time when you do it, it doesn't mean that you're entitled to be forgiven again because the landlord has the right to actually receive that rent on the debt that you agreed upon. And simply put, when we talk about a no waiver clause, what we mean is that the fact that you're violating that which you're supposed to be doing, and the other party is allowing you to actually do that, or ignoring what you're doing in terms of that violation, doesn't mean that they've given away their right for you to continue misbehaving in that direction. Before we discuss the 4th boilerplate clause, consider subscribing to Nairobi Legal Insights so that you receive notifications every single time I post a new video on contract law, management and negotiation in the Kenyan context. So as you can see on your screen, we are discussing about the severance clause. This clause is in most contracts, but the fact that you've seen it today, the next time pay close attention to it. So what we mean by a severance clause here is that should a specific provision within a contract be unlawful, then only that provision will be considered unlawful and the other parts of the contract will be considered enforceable and lawful. So if you have a contract that doesn't have a severance clause, the problem here is that without a severance clause, a void clause may cause the entire contract to become void, meaning that if you just have one provision that is void, then it can make the entire contract that you've signed become void. So this is the essence of having a severance clause within a contract. So with the exclusion of a void clause, meaning that if you had a void clause, then you can have the rest of the contract remaining intact, remaining enforceable. So as you draft, if you're a contract law student, remember to have this severance clause because as you can see, it has a huge impact. With it, only a specific part that is unlawful, unenforceable or void will be considered void and removed, and the other parts of the contract will remain enforceable and legally binding. So at all times, remember this. And so just to re-emphasize, this clause is to avoid the entire contract being void, just simply because one clause has been severed. And to be severed means one clause has been actually considered illegal, unlawful or unenforceable. So if you just go ahead and eliminate that specific clause or focus on it, then the entire agreement will still be enforceable while eliminating that specific provision or clause within the contract. Thank you so much for watching this video. My name is Rogers Gedinji, and for active engagement, you can follow our Twitter handle at Nairobi_legal so that we can respond to all your questions. If you liked this video, do not forget to give it a thumbs up and also share it with your friend. Asante.